Well, if you're a real estate investor in Colorado or a renter, you should know that the 2026 legislative session has just closed, and there were a number of laws that passed that will impact you as a renter or real estate investor in Colorado. Hello, I'm Mark Cunningham with Grace Property Management. The last few years, we have seen significant challenging legislation come through the legislature that has dramatically impacted landlords and tenants in Colorado. This year, 2026, the legislative session has just closed, and in our estimation, the rulings coming out of the legislature are much more fair this year and balanced. There's not nearly as many. It is a much more balanced session coming out. So let me take a few minutes and share some of the laws that did not pass. And the reason we want to share some of the ones that did not pass is because oftentimes these are an introduction to what we can expect to see next year. So legislatures will try to bring a law forth. It doesn't come through for whatever reason. The next year they modify that a little bit, and we see these things reintroduced and sometimes passed the following session. So HB 261106 had to do with eviction protection for tenants. Now it's important to know this bill did not pass through, and we're glad it didn't. It would have really slowed down and made the eviction process much more technically error prone. So it really didn't protect tenants in our opinion. For example, it limited the number of court cases that the judge could hear every day on evictions. So it doesn't matter how effective or efficient they are, it would put a cap on the number. It required some eviction cases right off the bat to be reviewed by an entire jury, which would take the eviction process out a number of months. It required some verdicts to be completely vacated, so the judge could slap down his gavel, vacate, decide on a case, and if the tenant made a particular request after the date, if it met a number of particular instances, the judge would have to vacate his prior verdict and restart a new trial, which doesn't make a lot of sense. And it would even prohibit evictions to be done if the weather was too hot or too cold. So it would have really slowed down and mucked up the entire just standardization, but that did not pass. Another one that did not pass was 1047, tenant protections. This would have just delayed evictions. It was another bill kind of doing the same. If a landlord posts a demand notice upon a tenant, they would also be required to post a copy of the actual lease agreement on the tenant's door, which is problematic for many reasons. It would require all tenant records be provided to the court when any filing is done on behalf of a potential evictions, and it would keep eviction records suppressed within the court system so they couldn't be shared. However, that did not pass. We may expect to see that back next year. Another that did not pass, HB 261036. This was a vacancy tax. This meant if you had a second home in Colorado or just a property you didn't live in, the municipalities had the ability to provide to assess additional property taxes on top of their standard property taxes simply because it was vacant. We're glad from the investor's standpoint that this did not pass. HB 261045, housing protections for tenants with disability. Now this did pass. All this does is it takes existing emotional support animal laws and support animals as it relates to ESAs, and it codifies those into Colorado law. It simply says that, hey, there's rules governing the way that a landlord processes a tenant request for an emotional support animal or an assistance animal, and landlords have to follow those processes which are already mandated federally. So this is probably a good thing for tenants and landlords both, to kind of make sure we have a standardization of what that process is. And it's a very detailed, complex process, but it doesn't change that detailed, complex process. This is effective immediately. So upon the signature from the governor in July, this is now in effect. Another one that's in effect is HB 261030, the ratio utility billing system. This really pertains to multifamily. So if you were a landlord with a multifamily project, you're aware of the RUBS, it's called which is the resident ratio utility billing system that changed last year. The legislature last year passed a bill which really changed the system to make it illegal for landlords to back bill proportionally shared utilities. It made no sense, and the legislature realized they made an error there, so they passed this to correct the prior bill, and this is effective immediately as well. This, if you're a multifamily, you're fine with this. If you're not a multifamily, it doesn't make a lot of difference to what we do on the single family side. HB 261196, tenant data information and screening and eviction data protection. another very fair bill, we believe. All this simply requires is that we as a landlord, we disclose to the tenant prior to their submitting a rental application. We'd have to tell them who is processing their rental application, like what company we're utilizing to pull their credit and all that information. And we have to disclose in detail exactly what information we will be looking at. We'll be looking at your credit, we'll be looking at your income. Most landlords already do this, legitimate landlords do this, but this now requires that by law. And it also protects tenants certain privileged information in the case of court filings, which is, again, typically commonly already done by legitimate landlords in Colorado. We feel this is a very fair bill to be put in place. This goes into effect January 1st of 2027. HB 26054 is a security deposit exception process for post-closing occupancy. If you sell a house and you as the seller want to remain in that property, you're going to do like a lease back for a period of time. There was existing statutory language that prohibited the security deposit being more than 2 months' rent charged from the seller. So it got convoluted or correct or incorrect. This simply corrects what many feel had been an incorrect ruling earlier that allows a seller, when the property has just sold, to charge the individual who's staying in the home longer a security deposit, which would be fair in those instances. This goes into effect immediately. Again, kind of a not a big deal unless you are selling a property and you're remaining in as the tenant. A couple other ones quickly here. HB 261224, mobile home park financial protection, impacts landlords or owners of mobile home parks. They have to give additional disclosures to the tenants in that mobile home park in the case of rent increases, in the case they're going to sell the mobile home park, or other additional aspects. They're just required to have more disclosures that way. And then the last one, HB 261007, portable solar device restrictions affecting HOAs and housing providers. What this basically means is if you as a landlord or at HOA, your tenant comes to you or the resident comes and says, I want to install this portable solar device, you're required by law as the housing provider to allow that. It's a kind of complex and convoluted bill. It even says if the installer does damage to the property, they can't be held responsible. Well, who is held responsible? No one quite understands that yet. I don't know if this will be really tapped into by tenants because these devices are very expensive and the tenants would have to pay for the device as they're bringing it in. This goes into effect January 1st of 2027. We know we talked quickly there, but the good news is there weren't that many bills. There were some others that we were tracking, but those are the most impactful to you as a tenant or as a real estate investor in Colorado for 2027. Now we will see, or excuse me, for 26. We will see what the 2027 legislation holds. There may be some of these being reintroduced, but this is fair news for tenants and landlords both in Colorado. We believe that when property management is performed with integrity and transparency, it truly is pro-landlord and it's pro-tenant. So we're happy to see our legislature this year come in with that idea of we want to make a fair, level playing field for all the participants so it benefits tenants and landlords both. Hey, if you're a client of Grace Property Management, don't worry. We have all of these new bills handled for you to ensure that you are compliant. If you need assistance in the management of your property in Colorado, please consider us a resource. Jump on our website, rentgrace.com. Happy to be of service if we are able.